In this lecture, we will deal with another important landmark judgment delivered by the Supreme Court in that particular leading case, Charan Lal Sahu vs. Union of India, which exclusively dealt with the Bhopal gas tragedy, which was one of the greatest industrial disasters faced by India in the year 1984 due to the leak of the most poisonous gas methyl isocyanate, and it was from the plant of Union Carbide at Bhopal, which is otherwise called the Bhopal gas disaster. And in consequence, the Bhopal Gas Leak Disaster Processing Claims Act was enacted in 1985. So we would discuss further the very judgment as it is relating to very definition, interpretation of public interest, then administrative pragmatism, the efficacy of the central government and its role in this very important gas leak disaster that occurred in Bhopal, and the very significance of the case that relating to determining corporate liability as state a guardian than the very critics and conscience, and the implications as such a blueprint for future disaster, the corporate and government nexus, and the human rights concern, and finally you will discuss the conclusion. So, the very case Charan Lal Sahu versus Union of India in the 1990 is a landmark judgment that arose in the aftermath of the Bhopal gas tragedy, one of the most horrific industrial disasters the world has ever seen, and in particularly India. The case delved deep into issues of corporate liability, compensation, and the role of the state in safeguarding public interest, especially in the face of crucial human tragedies such as the Bhopal gas tragedy. So, the very introduction that in relation to the very background of the case, on the very night of December 2 and 3, 1984, a leak of methyl isocyanate gas from the Union Carbide plant in Bhopal led to the death of thousands, almost 3,000 died instantly, while affecting the health and well-being of several thousands. In the wake of the disaster, several petitions were filed for compensation and for stricter regulations on corporations to prevent such tragedies in the future. So the very core issue that relates to this case, as Charan Lal Sahu, as himself was an advocate, filed a writ petition questioning the constitutional validity of the Bhopal gas leak disaster processing claims act of 1985. The act provided the central government exclusive rights to represent all victims of the disaster, thereby barring individual litigations for compensation against the Union Carbide Corporation, which was a multinational corporation of the United States of America. And here the very judgment delivered by the Supreme Court in majority decision upheld the constitutional validity of the act. But the very rationale that was led by the court in relation to public interest, given the magnitude of the tragedy, the court recognized the need for a consolidated approach to compensation. Individual litigations might lead to inconsistencies and delays in dispensing justice. Further, the court, in case of administrative pragmatism, held that the sheer number of affected individuals should make individual litigations an administrative nightmare. Further, regarding efficacy of the central government, the court placed trust in central government to represent the best interest of all the victims. The very significance of the judgment leads to redefining what was corporate liability or corporate responsibility. The case spotlighted the concept of corporate responsibility and the extent to which corporations can be held accountable for negligence. Further, the very significance of the judgment of the court led to that state as the guardian by upholding the act the Supreme Court entrusted the central government with the role of being the sole representative of public interest in such magnitude of a vast tragedy. Then the very critic and concerns relating to while the judgment streamlined the compensation process, it also faced criticism for potentially limiting the rights of victims to seek individual redressal. Further, the very broader implications as relating to a blueprint for future disasters. The judgment and the act provided a potential roadmap for dealing with large-scale industrial disasters in terms of compensation and redressal, and the very corporate government nexus regarding that the post-judgment discussions intensified around the relationship between corporations and government, especially concerning accountability and the protection of public interest. Another facet that is having the significance in the judgment relating to human rights concern, the scale of the tragedy and the subsequent legal battles brought to the forefront the debate on human rights, corporate ethics, and the role of the state in safeguarding its citizens in such large scale disasters. So now we would like to conclude our discussion on this very important leading case, Charan Lal Sahu vs. Union of India, which remains an essential reference point in discussions related to corporate accountability, state responsibility, and the rights of citizens in face of large-scale industrial disasters. The case emerging from one of the darkest chapters in industrial history highlights the complex interplay between corporate interest, state responsibility, and the inalienable rights of citizens. The judgment, while not without its critics, underscores the challenges faced by the judiciary in balancing diverse interests in the pursuit of justice. So, this very landmark judgment in Charan Lal Sahu vs. Union of India undoubtedly closed the very doors relating to individual petitions for compensation, but it laid down the very principles of corporate liability, corporate accountability, the state's responsibilities, and state as the guardian in context to such large-scale, vast industrial tragedies and devastations causing death and injury to lakhs and millions. So also it provided a blueprint for future disasters and the very nexus between the corporate and government and how far its impact led on human rights of those victims of large scale industrial disasters and tragedy.